So the court meets this afternoon to hear Kuwait, Lebanon, Libya, Luxembourg, Malaysia, and Mauritius on the questions submitted to it by the United Nations General Assembly. Let me one more time recall that each delegation is kindly asked to respect the 30-minute time allocation for its presentation. This afternoon, the court will observe a short break after the presentation of Libya. I shall now give the floor to the representative of Kuwait, His Excellency, Mr. Ali Ahmad Brahim Al-Dafriri. You have the floor, Excellency.
Bismillah ar-Rahman ar-Rahim. Mr. President, honorable members of the court, it is a great honor to appear before you as the agent of the state of Kuwait in these proceedings. Kuwait deeply appreciates the extraordinary effort taken by the court to allow this hearing to proceed smoothly in light of the great number of participants. The current advisory proceedings are of extreme importance to the Palestinian people, Kuwait, the international legal order, and the international community as a whole. Kuwait has always advocated that peace fosters the observance of law and vice versa. Adherence to the United Nations Charter is an indispensable prerequisite for the definitive establishment of international peace. Indeed, peaceful relations are founded on accepted rules, and as such, peaceful relations among states are based on the provisions of the United Nations Charter. These include, notably, the principle of non-use of force and the peaceful settlement of disputes. These rules apply to all states. Respect for these fundamental rules contribute to the consolidation of international peace. Regrettably, the above-mentioned foundational rules have not been upheld in the case of Palestine. The conflict between the Palestinian and Israel, hereafter referred to as the occupying power, is an illegal occupation conflict involving, on one side, an occupying power equipped with all military means, and the other side, an occupied nation without defensive capabilities, facing daily expulsion, human rights violation, and all sufferings associated with any occupation situation. Over the past decades, the situation between the Palestinians and the occupying power has been extremely tense, resulting in a serious human rights law and humanitarian law violation committed by the latter. Various intergovernmental and non-governmental organizations have documented these violations by publishing comprehensive reports. This climate of violence compromises any possibility of reasonably discussing the issue at stake. This is further exacerbated by the recent development in Gaza. The occupying power has waged an illegitimate war on the Palestinians in Gaza, characterized by numerous international law violations. The ongoing flagrant violations have been highlighted in a series of statements issued, among others, by the UN Secretary General, the UN High Commissioner for Human Rights, and the special procedures of the UN Human Rights Council. The unprecedented violence in Gaza is a result of 57 years of illegal occupation of the Palestinian territories, and it must stop. The late Emir of the State of Kuwait, His Highness Sheikh Sabah Al-Ahmed Al-Jaber Sabah, I'm sorry, Mr. President, summarized the situation in 2018 by stating, We ask the whole world by stating, quote, sorry, Mr. President, quote, why do we ignore and do not implement Security Council resolutions? Why? We ask the whole world, why the Palestinian people plight continues? Why the international community incapable of resolving this cause? Why does the victims continue to be portrayed Why does the victim continue to be portrayed as a killer according to Israel's norms? Why does Israel always escape punishment? Why have all these souls been lost amid absence of world conscience? Unquote. Sorry, Mr. President.
Sorry.
Mr. President, distinguished members of the court, it is in this context that Kuwait appears for the first time before the court, following the adoption by the UN General Assembly of resolutions 77247, requesting the court to deliver an advisory opinion on two legal questions. The first question asks the court to evaluate the illegality of the occupying power's specific policies and actions within its occupation of the Palestinian territories, while seeking the court's determination of the corresponding legal ramification. The second question addresses the core issue. Has the occupation become illegal? Kuwait will demonstrate the illegality of this occupation, underscoring the necessity of its cessation. Mr. President, honorable members of the court, my distinguished colleagues will now address these issues in greater depth. Second, first, His Excellency Ambassador Tariq Al-Bannai, permanent representative of Kuwait to the UN, will address why the court does have jurisdiction to deliver the advisory opinion requested by the UN General Assembly. He will also highlight certain legal practices and policies of the occupying power. Second, Her Excellency Tahani Al-Nasser, Assistant Foreign Minister for Legal Affairs of Kuwait, will start by enumerating the grounds proving the illegality of the occupation of the Palestinian territories, hereafter referred to as the OPT. She will then focus on the legal consequences arising from the breaches of those fundamental rules. And finally, she will provide the court with a certain concluding remarks. Thank you, Mr. President, honorable members of the court, for the privilege of appearing before you. I now kindly ask Mr. President to invite Ambassador Al-Bannai to address the court.
I thank His Excellency, Mr. Al-Dafiri. I now give the floor to His Excellency, Mr. Tariq Al-Bannai. You have the floor, Excellency.
Mr. President, honorable members of the court, it is a tremendous honor and privilege to appear before you on behalf of the state of Kuwait. 20 years have passed since the seminal Wall Advisory Opinion. Today, in these current proceedings, the question of the illegality of the occupation of the Palestinian territory is directly before the court. With your permission, I turn now to my first topic, focusing on whether the court has jurisdiction to render the advisory opinion requested. In Kuwait's view, the answer is a categorical yes. Indeed, the majority of submissions in these proceedings argue in favor of the court's jurisdiction. Article 65 of the Statute of the Court provides that the court may render an advisory opinion, and I quote, on any legal question at the request of any organ or institution authorized by the Charter of the United Nations or in accordance with its provisions to request such an opinion, unquote. In turn, Article 96 of the UN Charter, quote, the General Assembly or the Security Council may request the International Court of Justice for an advisory opinion on any legal question, unquote. In practice, it is primarily the General Assembly that has most frequently utilized this procedure to date. After all, when the General Assembly decides to request the court to deliver an advisory opinion, this means that the request reflects an important concern of the international community, seeking a legal answer. The court itself observed that the General Assembly, within the scope of its peacekeeping responsibilities, has a broader perspective than that of the Security Council, as it also considers humanitarian, social, and economic aspects. An attentive look at the court's jurisprudence points to the fact that, quote, only compelling reasons may lead the court to refuse its opinion in response to a request falling within its jurisdiction, unquote. Although the court has the discretionary power to refuse to respond to a request for an advisory opinion for reasons of judicial propriety, it has not availed itself of this option thus far. In the present case, it is incontestable that the questions included in the relevant General Assembly resolution are clearly specific questions of legal character. Any attempt to qualify them as non-specific or non-legal should fail. It is worth noting that the court, in the Wall advisory opinion, rejected similar attempts. In essence, in the Wall advisory opinion, the central issue revolved around the construction of the wall and its impact on the right to self-determination of the Palestinian people. 20 years later, the context has broadened substantially. The court is now tasked with determining the legal status of the ongoing occupation of the occupied Palestinian territory since 1967, given its persistence for over 57 years. Prior to addressing the next topic, I feel compelled to briefly refer to an argument certain states have made, fallaciously alleging that the issuance of an advisory opinion might undermine ongoing negotiations and peace processes. This argument, Mr. President, honorable members of the court, is groundless and without merit. Kuwait has always underscored the importance of resuming peace negotiations with a view of reaching a just and comprehensive peace based on the terms of reference of the peace process, the resolutions of the Security Council, and the Arab Peace Initiative. However, the relevant UN resolutions and the Wall advisory opinion make clear that any negotiations that take place must have as their objective the achievement of a just and lasting peace in accordance with international law. The court has an important role to play in this regard by stating what the applicable rules of international law are, including the rights and obligations of the relevant parties, all states and the United Nations. This is exactly the purpose of the UN General Assembly resolution requesting the court to deliver an advisory opinion. By doing so, the court may in fact help revive negotiations and inspire a return to a peace process premised on international law. After all, the court's advisory opinions shed light on complicated legal issues, appeasing tensions, uncertainties, and potential disputes. Mr. President, honorable members of the court, I will now address our second topic, providing you with examples of the occupying power's unlawful and egregious policies and practices in the OPT. In the interest of time, I will limit my presentation to 3 policies, which demonstrate the true nature of the illegal occupation. The first is forced displacement. The second relates to the illegal settlements on and the annexation of the Palestinian territory. And the third is discrimination at a scale and nature that amounts to apartheid. The remaining issues were discussed thoroughly in the written submission of Kuwait. In the 1948 Nakba, 750,000 Palestinians were forcibly displaced. And since then, millions more. The situation has deteriorated exponentially since the illegal occupation started in 1967. The occupying power has engaged in a forced displacement campaign against the Palestinians by demolishing their homes and confiscating their lands. Forced displacement violates international law. The occupying power is under the obligation to ensure that its operations in the OPT comply with the Fourth Geneva Convention of 1949, relative to the protection of civilians, persons in time of war, to which it is a party. Article 49 of this convention clearly prohibits, quote, forcible transfers, individual or mass, regardless of their motive, unquote, which includes forced displacements, as well as expulsions from the OPT. Furthermore, Article 53 of the same instrument prohibits the destruction of property. Finally, under Article 147, illegal transfers, destruction, and appropriation of property carried out on a large scale is prohibited. As Kuwait explained in its written submission, the occupying power has also committed other grave violations of international law, including the policy of settling parts of its population in the OPT. This unlawful policy has and continues to be deplorably promoted by the successive governments of the occupying power. Since 1967, the occupying power has embarked on an intensive campaign of colonization. Some settlements consisted of just a few prefabricated houses, while others expanded to become fully fledged small towns. In early 2023, there were around 730,000 Israeli settlers and over 280 Israeli settlements in the occupied West Bank, including 230,000 settlers in East Jerusalem. These settlements are sustained by a network of military checkpoints and restricted zones, as well as Jewish-only roads and highways, all of which limit gravely the lives and livelihoods of Palestinians and violate their fundamental human rights. Both the construction of settlements and the transfer of settlers to the West Bank and Gaza are grave violations of international law. In particular, Article 49 of the Fourth Geneva Convention, which states that, I quote, the occupying power shall not deport or transfer parts of its own civilian population into the territory it occupies, unquote. It is also noteworthy, Mr. President, that settlers in the OPT are not governed by the same laws that apply to the indigenous inhabitants of the territory. Jewish settlers are provided with special rights, facilities, and subsidies that are denied to the indigenous Palestinian population. The occupying power's policy not only supports the existing settlers, but also incentivizes new settlers. The discriminatory policies and practice also violate the sovereignty of Palestinians over their natural resources, allowing the settlers and foreign companies to exploit the water and agricultural products of the occupied land without any benefit to the occupied population. It is widely recognized that the occupying power has codified its discriminatory policies and practices against Palestinians in its legislation. Specifically, it grants rights to Israeli Jews and systematically discriminates against Palestinians. For instance, the Land Acquisition Law of 1953 facilitates the alienation of confiscated Palestinian land for the benefit of various institutions of the occupying power. Quasi-public organizations, such as the Jewish Agency, engage in material discrimination, in particular through the allocation of confiscated Palestinian land to Israeli Jews. Mr. President, honorable members of the court, thank you for your kind attention, and may I kindly ask that you invite Her Excellency Tahani Al-Nasser to the podium.
I thank His Excellency Mr. Al-Bana, and now I give the floor to Her Excellency Mrs. Tahani Al-Nasser. You have the floor, Excellency.
Thank you. Mr. President, distinguished members of the court, it's a great honor and a privilege to appear before you on behalf of Kuwait. In the written submissions, the great majority of states participating in these proceedings, along with the 3 intergovernmental organizations, concluded that the occupation of the OPT is illegal. Kuwait firmly agrees with this view in its written submission. Kuwait identified several reasons proving the illegality of this occupation. I will provide a brief overview of these reasons for the court. The occupation violates a series of jus cogens norms. First, the obligation to respect the right to self-determination of the Palestinian people. The right of people to self-determination is a right clearly recognized in international law as evidenced by several instruments and as submitted by 35 states and international organizations participating in these proceedings. This is articulated in Article 1.2 of the UN Charter, which define the purposes of the United Nations, including, I quote, to develop friendly relations among nations based on respect for the principle of equal rights and self-determination of peoples, and to take other appropriate measures to strengthen a universal peace, unquote. The same obligations are expressed in Article 1 of the International Covenant on Civil and Political Rights and the International Covenant on Economic, Social and Cultural Rights. Second, Kuwait joined the participants in these proceedings who have concluded in their written submission that the ongoing military occupation of the OPT is illegal because it violates the jus cogens prohibition on the use of force. Third, the occupying power, by confiscating and annexing parts of the OPT, violates the prohibition on the acquisition of territory by force. This was underscored by 38 participants in the written proceedings. This fundamental norm was incorporated into Security Council Resolution 242 of 1967 and reaffirmed in Security Council Resolution 338 of 1973. Accordingly, the occupying power does not have the right to claim sovereignty over the OPT occupied since 1967. Fourth, the occupation is illegal because it obviously violates the law of military occupation. For instance, the occupation of the OPT is not of minimal duration. Facts clearly demonstrate that it is intended to be prolonged and ultimately permanent. A permanent occupation constitutes a serious violation of international law based on the verifiable evidence available to us. It's indisputable that this is precisely what is happening in the OPT. This prolonged occupation and identified violation of the Palestinians' right to self-determination renders the occupation illegal. Moreover, the conduct of the occupying power in the OPT violates the rules of international humanitarian law. In the World Advisory opinion, the court stated that, quote, the Fourth Geneva Convention is applicable in the occupied Palestinian territories, unquote. The court also determined that the Hague regulations are reflective of customary international law and thus applicable to the conduct of the occupying power in the OPT. Far from complying with the law of occupation, the actions of the occupying power disregard international law. These actions include, inter alia, the establishment of settlements in the OPT, confiscation of Palestinian public and private property, and its failure to protect Palestinians from violence caused by state actors and private parties, including inter alia armed illegal settlers. Finally, the occupation violates the jus cogens prohibition of apartheid. 21 participants in these proceedings supported this in their written submissions, while 14 maintained that the situation of apartheid qualifies the occupation as illegal under international law. The prohibition of apartheid is evidenced in various sources of international law. The occupying power is bound by the 1965 Convention on the Elimination of All Forms of Racial Discrimination, to which it is a party. Furthermore, it shall abide by the prohibition of apartheid as enshrined in 1973 International Convention on the Suppression and the Punishment of the Crime of Apartheid, which codifies customary international law. Several voices and independence experts have warned that the occupation of the OPT amounts to a regime of apartheid. For instance, in March 2022, the Special Rapporteur on the situation of human rights in the Palestinian territories occupied since 1967, in his report reached a similar conclusion. Kuwait, respectively, suggested that the above violations cannot be reconciliated with the fundamental rules of international law. Hence, the occupation must be declared illegal in accordance with international law and the relevant UN Security Council resolution. It must stop. This will guarantee the right of the Palestinian people to be available state and along 1967 borders with East Jerusalem at its capital. Mr. President, members of the court, the legal analysis of the question involved in these advisory proceedings demonstrate that the occupation of the OPT is illegal in contravention of the fundamental rules of international law. It is written submission, Kuwait did address the legal consequences arising from the occupying powers, numerous and long-standing violations of these rules. Please allow me to provide with a view d'ensemble. As indicated, the action of the occupying power and the occupation as a whole are plenarily incompatible with the rights of the Palestinian people and obligations of the occupying power under international law. Its breaches of these rights and obligations engage the occupying power's international responsibility. The occupying power must therefore take several measures. First, it must provide Palestinians with relief in accordance with the principles of customary international law on the responsibility of states for internationally wrongful acts. This must be achieved through the immediate cessation of its illegal occupation. Second, the occupying power must give assurance and guarantees of non-repetition of its international law violations. The occupying power shall commit itself to not repeating the same breaches in the future. Finally, the occupying power is under the obligation to make full reparation for the injury caused by its occupation and discriminatory policies and practices. As for all other states, they are obliged to refrain from acknowledging the legality of the situation created by the illegal occupation and associated illegal policies and practices. They shall also abstain from offering support or assistance to sustain the circumstances stemming from the unlawful occupation and associated actions. Third, the state shall also contribute to safeguarding the Palestinian population against war crimes, genocide, and the crimes against humanity, and ensure that those responsible for crimes committed within the framework of illegal occupation are held accountable. In turn, the UN shall refrain from acknowledging the legality of the situation resulting from the illegal occupation and associated actions. The UN shall also refrain from offering support or assistance to prolong the situation and should instead cooperate to bring an end to the illegal occupation. Mr. President, honorable members of the court's advisory opinion is now more than ever necessary to put an end to the illegal occupation of the OPT. Kuwait has sought to concisely summarize the grounds for finding that the occupation is illegal as a whole, and submits that each ground of illegality shall form part of the court's dispositif. We are confident that the Court will assess Kuwait's written submission and oral statement as an expression of its faith in justice, its support for the rule of law, and its desire for peace for all states in the region. Mr. President, honorable members of the Court, this ends Kuwait's oral statement. Kindly allow me, on behalf of Kuwait's delegation, to thank the Court for its kind attention, as well as the registry staff and the interpreter for all their support. Thank you very much.
I thank the delegation of Kuwait for its presentation. J'invite maintenant la
I now invite the next participating delegation, Lebanon, to address the court and call His Excellency Mr. Abdel Fattah Issa to the podium. Excellency, you have the floor.
Monsieur le Président,
Mr. President, distinguished members of the court, it is an immense honor for me to speak to you after having set out Lebanon's oral comments regarding the legal consequences arising from the policies and practices of Israel in occupied Palestinian territory, including East Jerusalem. Now, this is a subject of the greatest importance for my country and for, indeed, the entirety of the international community. The record number of requests to intervene before your esteemed court is the clearest proof of this. Having set out in writing the views of Lebanon on the different legal aspects of the questions posed, and in order to comply with brevity instructions, I will restrict myself to 3 points which have gained in importance given the seriousness of the events which have taken place since October on Palestinian territory. These 3 points are: 1, the propriety of the court's intervention. 2, peremptory nature of the norms of international law breached by Israel, specifically the prohibition of the use of force and the right to self-determination. And finally, the legal consequences arising from these violations. Now, looking at the propriety of the court's intervention, distinguished members of the court, Mr. President, we are but a few months away from the historic 20th anniversary of your opinion regarding the building of a wall in occupied Palestinian territory. Now, certain states had suggested during those advisory proceedings, as they indeed do today, that the court shouldn't give an opinion because that intervention by the court might block ongoing negotiations between the parties, might even render more difficult or even impossible the necessary political accommodation. That's a roadmap to be followed. Well, here we are, 20 years later, down the road without any negotiated solution, no negotiations at all, in fact. However, what we do have are thousands of deaths and a massive destruction of civilian infrastructure. To ask the court to not intervene, to not hand down an advisory opinion because there's a bilateral negotiation process that needs to be protected, some sort of political solution that needs to be preserved, is a perverse argument which faces politics and the law off, one against the other, whereas in all societies, including international society, these are two dialectically related complementary elements. The law is the framework which prevents political slippage, be it public or private level. It is the law which guarantees a minimum of justice in relations. Madame Chemillier-Gendreau, in 2004, clearly described this, pleading before you. I'm going to quote her now. The political sphere represents the clash of subjectivities between society's different protagonists in a direct process which produces an unmitigated balance of power. The legal sphere represents the transposition of that clash of subjectivities by reference to a pre-established standard, the legal norm, under a third-party authority offering guarantees of objectivity. Comparison with the reference norm by an impartial third party provides the prism of objectivity through which the factual situation can be rectified. End of citation. This objectivity, distinguished members of the court, it's this objectivity which we have come to seek yet again from you. Now, allow me now to move on to the second point, which relates to the peremptory nature of norms breached by Israel. As we've already mentioned in our written comments, the concept of peremptory norms has become clearer thanks to the hard work carried out by the ILC as of 2016. Talking of the work of the Commission, let me respond to comments made by certain states who would that the draft articles and conclusions of that Commission should not be considered as established concepts. This observation, distinguished members of the Court, minimises the role that this body plays on behalf of the UN General Assembly in the development and codification of international law. Let me invite the Court to examine this comment of mine regarding that in light of Article 38 of your statute. Coming back to peremptory norms, the Commission had established a non-exhaustive list of 8 peremptory norms. When Lebanon submitted its written statement, it considered that Israel had breached at least 4 of the 8. Since then, and given the horrors to which Palestinians in Gaza are subject, Israel is accused of breaching a 5th norm of the 8, and it's not the least, the prohibition to genocide. And this is historical irony at its saddest. As I said at the beginning, I will limit myself to 2 peremptory norms mentioned in our written statement: prohibition of the use of force and the right to self-determination. The justification of this choice seems obvious to me. The breach of these 2 norms by Israel is the indirect or direct cause of the violations of the other norms mentioned in our written statements, be they norms of international humanitarian law, human rights, or prohibition of apartheid. Were Israel to cease its occupation of Palestinian territory, including East Jerusalem, and accept the right of the Palestinian people to self-determination, all the other violations would disappear. Let me add in this regard that in the written and oral statements of many states, they refer to and even insisted upon the prolonged character of the Israeli occupation to characterize it as an illegal annexation of Palestinian territories. Now, this is a valid and correct argument, Mr. President, but it should be taken as forming part of aggravating circumstances of the crime and not the crime itself, because the crime is one of aggression. Indeed, since 1945, the use of force under international law is strictly regulated. Since 1967, Israel has been committing a crime of aggression, illegally occupying territories before annexing them. In other terms, the occupation of territories resulting from an illegal use of force is itself illegal, however long it lasts. So, there we go. That's the first peremptory norm violated by Israel. Now I move to the prohibition of the use of force. The prohibition of the use of force is one of the peremptory norms well established, and it's clearly set out in Article 2, Para 4 of the UN Charter, which stipulates, I quote, "All members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the purposes of the United Nations." In 1974, the General Assembly adopted in Resolution 3314 a definition of aggression, which enumerates non-exhaustively a number of ways force may be used illegally. According to the Annex to Resolution 3314, aggression is, I quote, "any military occupation, however temporary, any annexation by the use of force of the territory of any another state or part thereof, the blockade of ports or the coasts of a state." So, Israel's occupation of Palestinian territories, its blockade of the Gaza Strip, all of this are acts of aggression. This has been a finding noted time and again by the UN Security Council, which has ceaselessly demanded since 1967 that Israel puts an end to its occupation. The General Assembly, for its part, is more explicit in its condemnation of Israeli occupation of Palestinian territories. Recently, it declared, for example, the inadmissibility of the acquisition of land by force and therefore the illegality of the annexation of any part of the occupied Palestinian territory, including East Jerusalem, which constitutes a breach of international law. The court, for its part, has always asserted the unlawfulness of the use of force and acquisition of territory thereby, including in its advisory opinion on the wall, where the court also recalled the customary character of this prohibition. Now, some may question the application of the norm prohibiting the use of force on the basis that it's an interstate norm, but that would imply that the OPT are not part of a state. Well, to that, distinguished members of the court, you can respond that Lebanon, indeed, more than 140 member states of the UN recognize the state of Palestine and East Jerusalem as its capital. The state of Palestine is a member of a number of international organizations, UNESCO, OPCW, OIC, League of Arab States, PCA et al. And Palestine is also an observer member of the UN, whose Secretary General, Mr. Guterres, declared less than a month ago that the right of the Palestinian people to build their own fully independent state must be recognized by all, and any refusal to accept the two-state solution by any party must be firmly rejected. So this really would be an expedient moment for the court to give its opinion on this point. In any event, Mr. President, distinguished members of the court, the prohibition of the use of force is not limited under international law to relations between states. Any use inconsistent with the principles and purposes of the UN Charter. Now, Israel continues its occupation and its policies, which are clearly aimed at annexing Palestinian territories. They encourage settlements, confiscation of land, destruction of public buildings, private buildings, in order to render its presence an irreversible fait accompli. And this despite all the successive resolutions of the Security Council, starting with Resolution 242. Now, in light of the foregoing, Lebanon requests the court to consider once again that Israel is breaching the fundamental principle of the unlawfulness of the use of force and its corollary, the illegality of the annexation of territories by force. Moving now to the right to self-determination. Lebanon considers that the right of the Palestinian people to self-determination is irrefutable, and there are no more eloquent words than those employed by your court to assert this reality. I quote you. The court observes that the existence of a Palestinian people is no longer an issue, and that those rights include the right to self-determination. End of quotation. The right to self-determination is a peremptory norm of international law enshrined in a number of texts, including the UN Charter, and which establishes this right as one of the foundations of friendly relations between nations. That foundation of modern international law has many facets, and Israel has violated all of them. In its advisory opinion, the court examined the legal effects of the separation of Chagos Archipelago from Mauritius in 1965. It looked at the nature and the contents of the right to self-determination. And you recalled that the right to self-determination is a customary rule and that the resolution of the General Assembly 1514 had a declaratory character. This resolution, adopted in 1960, was one of the first texts to define the contents and scope of the right to self-determination, namely that self-determination of peoples implies that they can freely determine their political status and pursue their economic and social development. The resolution also mentions that all armed action or repressive measures of all kinds directed against dependent people shall cease in order to enable them to exercise peacefully and freely their right to complete independence, and the integrity of their national territory shall be respected. It also clearly indicates that any attempt aimed at the partial or total destruction of the national unity and the territorial integrity of a country is incompatible with the purposes and principles of the UN Charter. Moreover, Article 1, shared by the ICCPR and ICESCR, asserts as well the right of peoples to self-determination and rehearses the main constituent elements of this right. As I pointed out earlier, Lebanon considers that Israel is breaching all the constituent elements of the right of the Palestinian people to self-determination, which, 1, political and economic independence, 2, permanent sovereignty over its wealth and natural resources, and 3, territorial integrity. Israel's prevarication over the decades, despite all the agreements they concluded and the appeals of the international community to recognize the independence of the Palestinian state, is an ongoing violation of the first element of the right to self-determination. Israel's policy of confiscating agricultural land, exploiting water and mineral resources of OPT is a continuing violation of the second element, which constitutes the right to self-determination, namely the permanent sovereignty of peoples over their natural resources. The third constituent element of the right to self-determination, territorial integrity, was recalled by the court when you declared that the right to self-determination of the people concerned is defined by reference to the entirety of a non-self-governing territory, as stated in the aforementioned paragraph 6 of Resolution 1514. The court considers that the peoples of non-self-governing territories are entitled to exercise their right to self-determination in relation to their territory as a whole, the integrity of which must be respected by the administering power. But Israel, by its policy of colonization and construction of infrastructure linking the settlements, gnaws away at Palestinian territories, including Jerusalem. This systematic and continuing infringement of the integrity of the Palestinian people's territory is documented by a number of reports for international inquiries. So, Mr. President, we arrive now at the third point, the legal consequences of Israel's violations. The preceding points show that Israel continues to breach peremptory norms of international law, norms which create erga omnes obligations. The court already noted in its advisory opinion back in 2004, where you declared that amongst the international obligations breached by Israel were erga omnes obligations. Such obligations, by their very nature, concern all states, and given the importance of the rights in issue, all states may be considered as having an interest that these rights be protected. The nature of breached obligations entails a specific responsibility for Israel, but also a responsibility for third states. Indeed, the systematic and continuing character of the policies and actions of Israel lead to an aggravated breach which entails three types of obligations for states according to Article 41 of the draft articles on state responsibility recommended by the UN General Assembly in 2001. I'm going to look at those, how they apply to Israel and how they apply to third states. So, legal consequences vis-à-vis Israel. As I mentioned earlier, Israel is committing serious violations of public international law, according to the definition of Article 41 of the draft articles on state responsibility for internationally wrongful acts. As these violations are both continuous and systematic, Israel is held to seize these unlawful acts and to offer assurances of non-repetition according to Article 30, draft articles on state responsibility. Concretely, Israel, in this case, has to respect the principle of the prohibition of the use of force and its corollary, the inadmissibility of the annexation of territories. It must dismantle the settlements in occupied Palestinian territories and withdraw therefrom. The court had already asserted in its judgment on the legal consequences of the building of a wall in OPT that Israel must thus restitute the lands, the orchards, the olive groves, and all other property seized from any physical or legal person. Israel is also held to cease all violations of the Palestinian people's right to self-determination, to put an end to its occupation of OPT, and to recognize the state of Israel. Moreover, Israel will remain in a legal situation just so long as it does not apply the resolutions of the Security Council which deal with the different aspects of its occupation of Palestinian territories. Indeed, distinguished members of the court, you already said in 2004, I quote you, when the Security Council adopts a decision under Article 25, in accordance with the Charter, it is for member states to comply with that decision, including those members of the Security Council who voted against it, and those members of the UN who aren't members of the Council. To hold otherwise would be to deprive this principal organ of its essential functions and powers under the Charter. End of quotation. Given the foregoing, we could say, distinguished members of the court, that Israeli occupation of Palestinian territory is unlawful. It's illegal, both in its aim and in its conduct. As a consequence, Israel is obliged to unconditionally and immediately put an end to this illegal situation, which entails its international responsibility, and it must also furnish reparation. Now looking at third states. Given that the norms breached by Israel are peremptory norms, these breaches affect all states on account of their erga omnes character. Draft articles on state responsibility for internationally wrongful acts stipulates in its Article 41 that states shall cooperate to bring an end through lawful means any serious breach within the meaning of Article 40. 2. No state shall recognize as lawful a situation created by a serious breach within the meaning of Article 40, nor render aid or assistance in maintaining that situation. The court had already confirmed these elements which fall to states in case of breaches of erga omnes obligations when you said in the legal consequences of the wall in 2004, I quote you, given the character and importance of the rights and obligation involved, the court is of the view that all states are under an obligation not to recognize the illegal situation. They are also under an obligation not to render aid or assistance in maintaining the situation. It is also for all states, while respecting the United Nations Charter and international law, to see to it that any impediment to the exercise by the Palestinian people of its right to self-determination is brought to an end. End of quotation. In light of the foregoing, you can say that the consequences of Israeli breaches for third state are as follows. First, states have to cooperate all lawful means to make sure that Israel withdraws from OPT, stops its policy of expansion of settlements and dismantles extant settlements, and recognizes the right of the Palestinian people to self-determination. Secondly, states must not recognize the fait accompli situation that Israel's created in OPT. Above all, regarding the change of status and demographic situation of the city of Jerusalem. So, the Israeli occupation of Palestinian territory is illegal and has to stop unconditionally and immediately. Consequently, third states and international organization must support without delay all efforts aimed at putting an immediate and conditional end to this occupation and to abstain from all action or admission which might contribute to this illegal situation being maintained. Speaking about international organization, and given that the court is called upon to answer the questions addressed by the General Assembly of the United Nations, that organization has a particular responsibility. The Organization of the United Nations, and specifically the General Assembly and Security Council, must take all necessary measures to ensure the implementation of their relevant resolutions without delay, and examine additional measures necessary to put an end to all or remove all obstacles to the realization in the way of the Palestinian people to its right to self-determination, put an end to the prolonged occupation, colonization, and annexation of Palestinian territory by Israel, intermediate measures aimed at changing the demographic composition and the character of the holy city of Jerusalem. Distinguished members of the court, Lebanon requests the court to find that you have jurisdiction to respond to the request for advisory opinion contained in 77247, and to do this in the light of our written and oral comments.
Ladies and gentlemen, members of the court, the late Pope John Paul II once said, if you want peace, want justice, defend life. If you want life, embrace the truth. As the highest judicial authority in our globalized world, Lebanon urges you to help in giving justice to the Palestinian people so we can have peace in the Middle East. Thank you.
I thank the delegation of Lebanon for its statement.
Participating delegation in Libya to make its oral statement before the court. I thus call upon Professor Ahmad Al-Gihani to take the floor.
Mr. President, distinguished judges,
Monsieur le Président, c'est un honneur pour moi de représenter ma délégation devant votre cour. Tout d'abord, permettez-moi de dire que les souffrances du peuple palestinien, et plus particulièrement celles aujourd'hui de la bande de Gaza, sont la preuve criante des conséquences de l'incapacité de saisir la cause.
Scale and systematic heinous crimes being committed by the occupying power force, depriving the civilian population of food, water, and essential supplies. The aggression of the power of occupying power has not spared children, women, elderly people. There is no safe place for the people in Gaza to go to. The crimes amounted by Israel, the crime committed by Israel tantamount to the crime of genocide and other international crimes stated in the Article 5 and 6 and 7, 8 for the Rome Statute. This call on the international community as a whole and on organs of the United Nations to put an end to this tragedy and take concrete steps in order to enable the Palestinian people to realize their legitimate rights of self-determination. Therefore, we believe guidance from the court as the highest judicial organs in United Nations, and it is necessary and important. The presentation of the state of Libya before your court will address the following points. First, the jurisdiction of the court, then the legality of the occupation of the Palestinian territory, then the consequences of the Israeli illegal actions, and then the summit. We can start from the first point, that the jurisdiction of the court As you know, Mr. President, member of the court, that the Article 96, paragraph 1 of the United Nations Charter provides that the General Assembly or the Security Council may request the International Court of Justice to give an advisory opinion on any legal question. On the other side, the Article 65, paragraph 1 of the court's statute further stipulates that the court may give an advisory opinion on any legal question at the request of whatever body may be authorized by or in accordance with the Charter of the United Nations to make such request. These two provisions are, according to our view, sufficient to establish the competence of the General Assembly to request the advisory opinion from the court and the jurisdiction of the court to give the requested opinion. We go to the second point, the applicable law. The international humanitarian law. First, the international humanitarian law. It is, as you know, settled that 1949 Geneva Convention relative to the protection of civilian persons in times of war apply to the OPT, as noted by the court in the Wall opinion. In addition of that, the 1907 Hague Regulation have become a part of customary law and therefore apply to the OPT, despite the Israeli argument that the Fourth Geneva Convention does not apply to the OPT. The court found, as a matter of treaty law, that does indeed apply, as it would to say, and occupied territory to prevent an armed conflict arising between two or more high contracting parts. In 2001, the Conference of High Contracting Parties reaffirmed the applicability of the Fourth Geneva Convention in the occupied Palestinian territory, including East Jerusalem, Quds, and called inter alia upon the occupying power to immediately refrain from committing grave breaches involving any of the acts and mentioned in the Article 147 of the Fourth Geneva Convention, such as killing, torture, deportation, depriving of the rights of fair and regular justice and trial, extensive destruction and appropriation of the property not justified by military necessity. Plus that is applied the international human rights law. A variety of international human rights treaties apply to the proceedings. Among the most important of these are the International Covenant of Civil and Public Rights, International Covenant on Economic, Social, and Cultural Rights, the International Convention on Elimination of All Forms of Racial and Discrimination, the International Convention of the Elimination of All Forms of Discrimination Against Women, CEDAW, the Convention on All Rights of the Child, and the Convention Against the Torture and other forms of cruel, human, degrading treatment and punishment. Both states, Palestine and the occupying force, are parties to these treaties. Established norms of general international law applicable to the proceedings. As stated by the International Law Commission, norms of general international law, jus cogens, embody three essential characters. One, they protect the value of fundamental to the international legal order shared by the international community as a whole. The second, they are universally applicable by virtue of their non-derogability, since states cannot derogate from them by creating their own special rules that conflict with them. They are superior on other norms of international law, entailing obligation of an erga omnes character. The court itself has recognized the erga omnes character of such obligation. These are the norms. First, the inadmissibility of the territorial acquisition by threat or by use of the force. The prohibition against the threat or use of the force against the territorial integrity or political independence of another state is enshrined in the Article 2, Paragraph 4 of the United Nations Charter and is an essential cornerstone of the international legal order. The article, I quote, the Article 2.4 provides that all members shall refrain in their international relation from the threat or use of force against the international integrity or political independence of any state, or in any other manner in accordance with the purpose of the United Nations. In case of the armed activity on the territory of the Congo, the court stated that the prohibition of the use of force is a cornerstone of the United Nations Charter. Then we go to the second paragraph, which is the prohibition against racial discrimination and apartheid. The prohibition of racial discrimination and apartheid is reflected most in third, as the court has very recently underlined that 182 states are parties in the third, a fact which confirms that universal character of the convention. Those parties include both of state of Palestine and the occupying force. It is well established that the prohibition of the racial discrimination forms part of customary law and has long been recognized as premonitory norm. The court in Barcelona Traction considered the prohibition of the racial discrimination to be a norm of erga omnes character, stating that such obligations derive from, example, contemporary international law from the outlawing of acts, aggression, and genocide, as also from the principle and rules of concerning the basic rights of the human person, including protection from slavery and racial discrimination. Third, the obligation to respect the right of the self-determination. The right of self-determination exists in customary international law and recognized by the United Nations Charter, as well as in the ICCPR and ICESCR. It must be also stated that the obligation to respect the people's right of self-determination is premonitory principle of the general international law. As the court noted in the East Timor case, that right in self-determination is one of the essential principles of contemporary international law, enjoying an erga omnes character. The United Nations General Assembly has repeatedly confirmed the right of Palestinian people to self-determination. For example, the resolution 2672 of the 8th December 1970. It recognized that the people of Palestine are entitled to equal rights and to self-determination in accordance with the Charter of the United Nations, and that full respect for the inalienable rights of the people of Palestine is an indispensable element on the establishment of a just and lasting peace in the Middle East. Mr. President, members of the court, now we come to the illegality of the Israeli occupation of the Palestinian territory. The Israeli 6 decades occupation of Palestinian territory is a continuing gross and systematic breach of its legal obligation under the United Nations Charter and the general international law, also international humanitarian law, international human rights law, and customary international law. including the violation of at least 3 premonitory norms of general international law, of jus cogens and erga omnes charter. It shows that Israel has annexed and plans to continue to annex Jerusalem, Al-Quds, and the rest of the West Bank. That has composed systematic and comprehensive racial discrimination tantamount to apartheid against the Palestinian people, based on their race, and that it has denied their right to self-determination in their own land. In view of these policies and practices, Israel's occupation of the OPT is unlawful, rendering Israel's continued presence in the OPT and internationally wrongful act as seriously breaches the last 3 premonitory norms of the general international law. Derogation from which is not permitted. Israel's occupation of the Palestinian territory seriously breaches premonitory norms of the general international law, and the occupation of the OPT seriously breaches the at least 3 premonitory norms of general international law, derogation from which is not permitted. On the matter of self-determination, the occupying power has not only denied, Israel has not only denied the right of the Palestinian people to self-determination, but actively tried to suppress and to extinguish it even after the court's ruling in 2004. That Israel has under obligation, erga omnes, to respect the right of the Palestinian people to self-determination. Israel has, in fact, escalated the policies and practices with the specific intention of permanently precluding the exercise of the right of Palestinian people, including their right to independence and in their state. It is very apparent and evident that the General Assembly considered the Israeli military occupation as illegal, and Security Council the overriding necessity to the prolonged occupation when the occupation was in its early years. There is no doubt that it is unlawful, is even more apparent of the flagrant now that has come to the 6 decades. As consequences of Israeli prolonged 6-decade occupation of the OPT is a clear violation of premonitory norms of the general international law, derogation from which is not permitted. The occupation itself must be regarded as illegal with all relevant legal consequences that attach under the law and international responsibility. This means that it must brought to an immediate and unconditional end and total end. Mr. President, distinguished justice, what we mentioned is also means that the Palestinian people has the right to resist the occupation by all means, and it is a moral and legal obligation upon all states to assist and support the Palestinians in their legitimate struggle for liberty and independence. Now, Mr. President, members of the court, come to the consequences. We start by legal consequences on the occupying power. It must fulfill the occupying power, or Israel must fulfill its obligation to respect the Palestinian people's right to self-determination. Israel must immediately end the violation of the international obligation to respect the right of the Palestinian people to self-determination by ceasing all acts and measures that prevent and impede the Palestinian people from exercising their right to self-determination, including the immediate cessation of the occupation in all its manifestations. The obligation of the state responsible for an act contrary to the international law in general and international law. Accordingly, Israel is obligated to immediately cease of violation of the legal obligation in Jerusalem and the occupied Palestinian territories as whole. The cessation of this violation includes, inter alia, the dismantling of the illegal structure, including the settlements and the wall. Israel shall be obligated to make restitution and compensation for the damage suffered by the Palestinian people, and Israel obligated to immediately repeal all the laws that aims to racial segregation and discrimination enshrining in the apartheid regime imposed against the Palestinian people. The other consequences, the legal consequences for the third parties or for the third states. Given the orga omnis nature of the right to self-determination in accordance with the standing resolution of the United Nations General Assembly, it is also incumbent on all states to ensure that any impediment to the exercise of the right of self-determination by the Palestinian people is brought to an immediate end. In view of the nature and importance of the rights and obligation involved, all states have an obligation not to recognize the illegal situation resulting from Israeli violation in the occupied Palestinian territories, including Jerusalem. They are also obliged not to provide aid or assistance in maintaining the situation created by these illegal acts. Furthermore, the states parties to the Fourth Geneva Convention are obliged to ensure that Israel complies with the international humanitarian law as enshrined in that convention, including the forcible transfer of Palestinians and the transfer of Israeli citizens in the occupied Palestinian territory. Also, there is a legal consequences on the UN and all the United Nations. The United Nations, and in particular General Assembly and the Security Council, should consider what further measures are necessary to remove without delay any obstacle of the realization of the Palestinian people's right to self-determination, and to take necessary measures to ensure the implementation of its relevant resolution without further delay. Then also the United Nations should consider that further action required to bring illegal occupation, ensure the implementation of the relevant resolution without further delay. Mr. President, distinguished judges, lately we have the Libyan state submission. I will, with your permission, I will give the floor to my colleague, Dr. Nasser Al-Ghita.
I thank Professor Al-Kihani, and I'll give the floor to Mr. Nasser Al-Ghita. You have the floor, sir.
Mr. President, members of the court, it is my honor to appear before you today on behalf of the state of Libya. And with your permission, I will proceed to the final points of our presentation today, which is the submissions to the court. We submit to the court that the court has jurisdiction to deliver the advisory opinion requested by the General Assembly, as there are no grounds for declining to exercise its jurisdiction. We believe that Israel is responsible for serious breaches of obligations arising under peremptory norms of international law, including but not limited to the illegality of the admissibility of the acquisition of territories through the use of force and the prohibition of aggression, the prohibition against racial discrimination and apartheid, and the right of the Palestinian people to self-determination. The occupying power is obliged to immediately, unconditionally, and completely end its occupation and withdraw from the OPT. This entails, inter alia, revoking all legislation and measures aimed at the annexation of Jerusalem and the rest of the OPT. End of aggression, the blockade on Gaza, withdrawal of all occupation forces, and dismantling of its illegal settlements and their associated regimes. To revoke all of its discriminatory legislations, measures against the Palestinian people, and to respect the unalienable rights of Palestinian people to self-determination and the Palestinian refugees to return to their home. To provide assurance and guarantees of non-repetition of the above-mentioned violations. To make full reparation for injuries caused by the policies and practices vis-à-vis the state of Palestine and the people of Palestine. As a result of the internationally wrongful act or actions. All states and international organizations, including the United Nations, are obliged not to recognize the illegal situations resulting from the international wrongful act of the occupying power. Not to contribute to the violations of the right of the Palestinian people, and by not rendering aid or assistance in any way to the occupying power, to cooperate to protect the right of Palestinian people and to end the occupying power's violations of those rights, by enabling the Palestinian people to exercise their right to self-determination, and by holding accountable those responsible for crimes related to the colonization of the West Bank, including East Jerusalem, the unlawful annexation of the OPT, and the blockade and the current aggression on Gaza. And more generally, the violations of the fundamental rights of the Palestinian people as a whole, including the right to self-determination and to be free from racial discrimination and apartheid, as well as the right of Palestinian people to life and liberty. I would like also to stress that our observation before the court today has no legal effect in relation to the recognition of Israel. Mr. President, members of the court, this brings our presentation today to the end, and I thank you and your member of the court for your kind attention. Thank you.
I thank the delegation of Libya for its presentation. Before I invite the next delegation to make its oral statement, the court will observe a break for 10 minutes. The sitting is suspended.